Good day, folks. Welcome back to Ancestry Legal. Joining me today is Melissa Belcher, the owner of the law firm. Specialist law firm that focuses exclusively on estate planning, as we've already established. In our previous episode, we dealt with what is a will, what is a trust. We've received a follow up question, which is really pertinent in today's world because so frequently and so easily in this world of the internet can we go shopping online. And I believe that wills are not excluded from that process. So the question that we've received is, well, my mom downloaded a will online. We had the people at the bank sign it, but the lawyers said it's not admissible. So what does that even mean? And why is this the case? And what's the remedy?
Oh, that is a really good question. So what does it mean that the will was not admissible? So we talked about in the previous video that your will, after you pass away, then it's triggered and you have to present it to the court. You open a case and it has to be probated. But before it can be probated, it has to pass the legal threshold at a minimum that it was signed properly, it was witnessed properly, and you have to give people the opportunity to contest it. If they sometimes people might say, "Oh, she was suffering for dementia for 5 years, but then she changed her will 1 week before she died," and so that's a little suspect. So first, it would have to be pass the legal threshold that it is a will, it was signed properly, the person knew it was a will, they were signing it voluntarily, all these different things before it becomes admissible in court as a will and as your last will and testament. So that would be the admissibility of it. And then if it, so these are all sorts of different possibilities of why it would not be admissible. If there's questions about the authenticity of the document, and is it the original? Was it signed? Is it truly that person's intent? So that's why it may not be admissible. And it just depends on the state, maybe where it was signed and written, and what state that you're trying to admit this document in court. So it would have to be recognized based on where it was written and where you're trying to admit it.
All right. So downloading a will online and simply having it signed by someone at the bank, or writing your own will, leaving it in the closet underneath your favorite t shirt to hope that it will be found, is not necessarily the way to go.
Correct. And there are lots of options to purchase a will electronically, print it off, fill it in, and I can't speak to all of the services that are out there or packages that you can buy at the local office depot or, any type of retail store. But it's really important that you make sure that you sign it and it's witnessed as it should be, because a lot of people think they have a will and they they don't. They just don't.
Okay. Another question that's come up is that, can we add stuff to the trust to avoid probate taxes? So stuff like houses, stuff like bonds, cash, gold, right? Because you can see on TV, lots of people are buying gold. Um, can you do that? Can it be put in the trust to avoid probate taxes?
Well, can you put can you put your assets into a trust? Yes, you can put assets into a trust. Should you put the assets into a trust? It depends on the asset. It depends on, what category that the asset is. When we're talking about your bank account that you use to pay your normal bills, then you probably wouldn't want that in the trust, because if it makes it more difficult to access those funds. Your gold bar, would you want to put that into a trust? Maybe. It just depends. Um, can you put it into a trust to avoid probate taxes? You can utilize tax strategies. You can use a trust to use that as a strategy to avoid probate, and you can. A trust is definitely the way to go to avoid probate, but you can't necessarily just use a trust. And there's several different types of trusts to avoid taxes. If But you can employ tax strategies. That's where the consulting with an estate planning attorney, with a tax strategist, with your CPA, you want to utilize a team who understands the complexities and the pros and the cons. It depends on what is your goal, what are you trying to achieve, and then we put together a plan accordingly based on your situation and your assets.
Okay. So just to be very specific and very clear in terms of what I hear you say, you're not avoiding taxes, right? It's not tax avoidance. Rather, you are understanding what the requirements are and how you would limit your tax obligations legally. Is that correct?
Yes, but I do want to clarify one thing. So, tax avoidance, there's nothing wrong with that by employing tax strategies. Tax evasion, that's the problem. That's a criminal issue. But tax avoidance is absolutely what we do. But you can't just say, okay, I'm going to put it in a trust and I'm going to avoid probate taxes. So, the threshold for the exemption amount for probate taxes at the federal and state level is pretty high right now. But then that law is about to sunset. And if nothing changes, then a lot of people might have to readjust or really look at and evaluate what their current trust looks like. And then do we need to make some modifications in order to avoid probate taxes?
When I hear you speaking, I hear about lots of variables that people could face given uniqueness of circumstances. Um, these variables are starting to sound to me like the consultation session you spoke of in our previous video is sounding like it's more and more of a necessity, or is the window still open to go down the route of a DUI option and let me go and do my own MacGyver trust?
Did you say a DUI option
Um,
or a DIY?
Sorry, I mean, do it yourself.
Yes, yes, yes. So
Yeah,
DIY, that's a good thing.
I was watching a law program where they were catching people for driving under the influence, but I'm talking do it yourself.
Yeah.
So slightly different, but they're close. They use similar letters.
They do. I just wanted to clarify on that one that we're not doing a DUI session.
Yeah, so don't write your will under the influence either, because you may get it wrong.
Right. And then we worry about knowingly what you're doing. But yes, so the more complex, depending on what your goals are and what your family situation is, what your assets are, then we definitely, I don't recommend doing a DIY.
All right, so no DIY while under the DUI. All
Correct.
Right, got it. So excellent. Consultation session, folks, clearly becoming an issue. So continuing on the questions that have arisen, and we spoke of this modern family and the fact that we could have, direct descendant children, we could have stepchildren, we could have the matter complicating somewhat when it becomes grandchildren. So, in this event, do I need to have separate trusts for each of my minor children to protect what they inherit? Or
I actually like that practice because if you decide that they each get a specific dollar amount or a specific percentage and they're getting the same amount, each child is different as far as their needs or desires education wise. Maybe one wants to go to college and the other one doesn't. They would rather go to a vocational school and work on skills. That's fine, but why should one child who wants to go to an Ivy League school get all of that covered, and then the other one decides to go to a skill, or maybe go to a vocational school learning mechanics or something, and their school only takes 25,000, but you've got a $200,000 bucket for each child. But then if it's not separated, then it one child could actually take more than the other just because of choices or desires or abilities that they have. So if they each get the same amount, let's use an example, 200,000 each, one goes to school, it's only 25,000, then he starts working. Why shouldn't that child have 175,000 to sit there and stay invested, or go into his, let him use that as a down payment on a house, as opposed to the other one who gets out, goes to an Ivy League school, it's 200,000, you pay for that 100%, and then they're going to be making a lot more. So you don't have to, but I like that practice.
Okay, so the second part of that question was ensuring that their children will be inheritance or will remain inheritance. So we have this complex scenario. I leave assets to one of my children. That child then goes and gets married. They have kids. I want my grandkids to inherit from me, either directly or indirectly after the passing of their parents. But that child then marries, that child then divorces, and should there be no trust, the assets could get split 50-50, and then all of a sudden my assets are now going down into a family tree that I never contemplated or do not specifically do not want to have them inherit from my estate. Does this take care of it?
Well, yes, if so, that's part of the family, like the planning meeting is, what is it that you have and where do you want it to go? And if you explain that to me, then we put it into the document, like this is how you want it. It wouldn't be distributed to the parent because it could move from one family tree to another if it's an outright gift. That's not your intent. We can tie it up, make sure that it is absolutely protected for that grandchild's benefit. And then if that grandchild gets married, it doesn't leave the trust, but the child can still benefit from it. And we can also, write in there that the child doesn't get married unless they get married with a prenuptial agreement to protect it. So otherwise, they waive being a beneficiary. There's lots of things that you can do. It's your stuff, it's your rules.
All right. So, really important to consider, folks, is how those assets go through the generations that come after you versus they get redirected down another route. So, as already established, I leave an inheritance to one of my children. They get married, they get divorced. In that case, there really shouldn't be a transfer of assets because I have not yet died. But should I die, and should those assets be transferred, now all of a sudden we have a situation that kicks in that half of what I've left that child, if there's no antenuptial, could disappear in a divorce. That person remarries and has children with a new partner, and there you go. My inheritance goes into that family. My own family have now become disinherited.
Correct. Accidentally, yes, that happens, and we can avoid that situation.
All right. Thank you so much, Melissa, for sharing with us again today. So, folks, remember, if you want to get hold of Melissa, easy way to reach her, is Melissa at ancestrylegal.com, not ancestry law. So now you must watch carefully what I say because I think I'm misguiding you. Ancestrylegal.com, Melissa at ancestrylegal.com. So look forward to seeing you in the next episode. Thank you so much, Melissa.
Thank you.